Welcome, everyone, to this Tuesday, May 18th edition of Money, Banking, and Trust, Titles and Commerce. I'm your host, Chrisitan Walters. Welcome to NTT's New Trust Technology. And this is Tuesday, so we'll just have a general Q&A right now. I had planned to go over some equity things, but I didn't have a chance to put it together. So do we have anybody with some questions? Want to kick it off? Press star 6, state your name, where you're from.
Yeah, Christian, this is Floyd.
Hi, Floyd.
Hi. Yeah, I have a question on pulling your name out of general deposit and put it into special deposit.
All right.
What is the procedure for that? In other words, now we're talking about our real man name. We're not talking about our straw man, right?
Oh, the real man name? Pulling the real man out name? Special general deposit, put him in special deposit. Huh?
Yeah. Isn't that the one that we're dealing with?
Yeah, the signatures, yeah.
Okay. Okay. Now I know when we
you brought up a good point there, because really, as you signing for suretyship as for the straw man, if we do the withdrawal, that withdrawals from general deposit all ties with that, including the suretyship.
Yeah. Well, I know that when we capture the straw man, we do that with we did it. We used to do it with the UCC1. Now I suppose we would have to do it by notice, like we do everything else, right?
Well, the paperwork is still the mechanism, moving titles platform, same thing. Nothing's really changed except maybe just a little better understanding that we were actually doing a withdrawal.
Okay, but now what I'm wondering is when we pull the name out of general deposit, who are we assigning that name to? I mean, it's our name. And we own it, but how are we noticing the public that this is my name and I'm no longer using this as a general deposit? What would I call it? Not a res, but this is where I'm kind of floundering as to.
Something new, that's it. But you really said it right there. How do we do the claiming?
Yeah, exactly.
Well, how do we do? How have we been talking about doing the claiming normally?
Well, normally we put it on the UCC1 and
there you go.
Okay, but
so what we're claiming is we're just setting up a public notice record that we've claimed it.
Okay, but I don't have to transfer it to anybody, though, do I? I mean,
Who's got it?
Huh?
Who's got it, though?
Well, the general deposit has it.
Right, now who's that? Whoever you gave it to.
Yeah, well, that could be any number of people or any number of corporations or... So
let's take a specific circumstance here. Let's say it was a credit card company and you gave them your signature. Now they've got it, ABC credit card. So you put the claim your name again on the one, but who's got it? ABC credit card, because you gave it to them.
Yes, that's okay.
Now, if they've got it, how do you get it away from them?
Well, you have to put it on UCC3, name them as a debtor, and you're the grantor.
Yeah, you want to transfer it on a 3 from them to you now.
Okay, from them. Okay, let's see.
So now they don't have it anymore.
Okay, so let me think here a minute. I would be putting.
First, I'm going to set up ownership by claiming it that it's mine, and I do that on a UCC1 in the county.
Right.
since I gave it to the bank, ABC Bank, they've got it. They're holding it because I gave it to them.
Yeah.
Now I got to get it back. So I've got to do a UCC3 transferring it from them to me along with the county again. Now I got 2 records to prove each thing. Now it's mine. I claimed it's mine, and I'm holding my name again.
Okay.
Now that's the withdrawal.
Mm-hmm.
So now I'm going to deposit my name as a special deposit.
Yeah.
So
Okay.
now what do I do next?
Well, I have to do another UCC1.
No, I already claimed it.
Oh, I already claimed it. Okay, so now I have to do another UCC3.
Right. Transfer it back to them. Except this time it's under special deposit.
Okay. I was wondering, is there a way that we can do that? Well, I know that we're going to go for the Sedicate Trust situation, but until we do that, there is no way that we can just make a claim for all time, a one-time claim for all purpose transfer back to me so that I own it under all circumstances.
Well, when you transfer it again to them the second time, now you put it under trust and you retain ownership because it's just they're supposed to keep it in trust to return to you the same thing that they got or for the specific purpose that you specify.
Okay, so then
under a general deposit, when you gave them your name, you transferred title to your name also. Now they have the title to it under general deposit. Under a special deposit, when you transfer the res, which would be your name, say, you retain title.
Yeah. Okay. So ABC company, credit card company that I have transferred my name back from them back to me, and now I have it in. I have now put it in trust. So the next time that I go to XYZ credit card company, I don't have to reclaim my name and take it back from them and put that in on a UCC3 back to me again.
Right. You've already claimed it once.
Okay. So I could do that. Okay. So then I could do that with if I have an issue, like I have an issue with Sprint right now, for example.
Right.
If I do that with Sprint and claim my name back from them, put my name in trust, then at that point, if I go to Dell Telephone, for example, or whatever telephone, and make an agreement with them, then I can just say that I can just use my name as my name without having to be concerned about reclaiming my name again.
Okay, but you give them a copy of UCC1 claiming your name, and that way you don't have to file another UCC1, but you still got to give them notice that you got a claim on your name.
Yeah, okay, that part is okay, but I just don't want to have to be doing a UCC1 every time that I deal with another company for different reasons.
Right. All you have to do is use the one that you've already, UCC1 that you've already filed, and just make copies of it, certify the copies yourself, and just send them a certified copy that you've claimed the name.
Okay. Okay. So when you say I certify the copy myself, what do you mean? You mean just make a copy and then take it to a
notary? For the original documents, they have the right to make certified copies off the originals because they're your documents.
Yeah. So
the holder of the original documents, you go to the county, usually the reason why they can make certified copies, or in the court, they never allow the originals to leave, and they maintain the originals. That's why they can certify copies, because they got the originals.
Oh, okay. So because I have the original, I can certify copies in.
Yes.
Oh, okay. All right. So I just put certified
You can
copies.
give certified copies because you can make copies and certify them to be certified copies because you got the originals.
Okay, I see. Okay. All right. Well, then that would be one good reason just to continue on with what I'm doing with Sprint, even no matter what else we.
You've already filed a UCC1, right?
Yeah.
And you've already claimed the name, right?
Yeah.
Okay. Now,
Well,
there may be a timing sequence that may be off here. All you lack was just the transfer on a 3 from them to you, and then another 3 transfer back again from you to them.
Well, I haven't actually put my name down as claiming it, in specifically saying, well, I claim this name, and put it, I haven't really done that. What I've done is I've done a UCC1 and a UCC3 on the procedure of claiming the bill or whatever it is that I'm doing with them.
And the 3 was a transfer from you to them, right, as a special deposit?
Yes.
Okay, so we're missing the step from another 3, which should have been done, say, prior in a sequence, although it wasn't done, so you can correct the mistake by still doing one. Do a UCC3 again, transferring it from them to you. You've already got a 3 in place, transferring it from you to them.
Mm-hmm.
You just need an unbroken chain of documents that proves that you transferred it from them, you claimed it transferred from them, and then send it back to them, transferred it back to them.
So all I do then is I take the UCC3 that I have already on file, and I just then make myself the well, actually I'd be making myself as the grantee on that one, right? Or the debtor? Because I'm the secured party I'm the secured party already.
No, there's no secured party on those forms.
Well, and grantor, that's the way it comes out. I mean, when they.
I know you did the nomenclature change, right?
Pardon?
You did the nomenclature change, right?
Yes, I did.
Okay, then there is no secured party on those forms.
Well, that's what it reads on the before you.
Yeah, I know that's what it is, but it's not, it really doesn't. It changed all the headings to what you specified, which would be grantee, grantor.
Right. Yeah, grantee, grantor. That's okay. So then I would be.
So your secured party creditor would be the grantor now block.
Oh, okay. So then when I do a UCC3, then I go grantor, grantee.
Yeah, you don't have to change the wording or the blocks or the switching of any names. You just have to change your description of what you're doing in the collateral block.
Oh, okay. So in the collateral block, okay. Okay, help me out with the wording so I know exactly what I'm doing.
Take verbiage that you transferred with the 3 from you to them and reverse it, transfer it from them to you.
Okay. All right. Okay. All right. I'll look at that, and then I'll know what I'm doing. Okay.
You may have to switch the verbiage around a little bit, but now instead of transferring it from you to them, you're going to reverse that and switch it from them to you.
Right. Okay. Now
them to you.
And then that goes on. Right. That goes on record for the next 5 years as well.
Yes. This wasn't done before the first UCC3. Make it so that it's worded so that it takes place as being before the date of the transfer to to them on the UCC3.
Where would I do that?
Non-pro-tunc back to the filing, say, before the filing of the UCC3, the first one.
I see. Okay. All right. Okay. All right. It's probably going to. Well, I'd like to have. Let's see. I do need to send that in with my other UCC3, don't I? To Sprint, to show them that is my.
Yeah, you'd have to send them at least the 2 UCC filing transfers.
Yeah.
Proving that you withdrew it and that you gave it back to them as a special deposit.
Right.
If you want, you could include the UCC1 to prove that you claimed it, although that's kind of optional, I think.
Yeah. Okay. Well, I have it, so I mean it's no problem. And,
right.
And
you can include it if you want to.
I did go back in, and this time when I went in and pulled up my filing, I could get my form. The form came up with everything in it, and I could actually print it out.
Mm-hmm.
I mean, that was after I had filed it, and I went in the next day and pulled it up and did it. And I couldn't do that before, so I wasn't doing something right.
Well, did you do it the same way you did it the first time, or maybe it wasn't on file just exactly at that time?
Well, all I did was I put in my UCC1 file number, and I pulled that up, and then I went in and I pulled up the UCC3 file number, and that came right up too. And I was having trouble pulling up the UCC3 the first time, and all I could get was what it looked like a receipt. But this time it came up with the form. So
maybe it took a little time to get it in there.
Well, that could very well be it. Although when you do something, it's almost immediate anyway.
You think so?
Well, yeah. I mean, you can go in 5 minutes later and file your UCC3 after you file your UCC1, and it's a transfer right immediately. So anyway, I know that I had complained about that before, but this time it worked out better. I mean, it worked out the way it was supposed to. Okay, so anyway, that answers my question, because I was trying to figure out how you would claim a name that you already owned.
The trouble is you don't own it. You gave it to them, and you don't own it anymore.
Well, yeah. Okay. Well, yeah. Okay. All right. Very good.
You gave it, and give by definition of Black's law was that you transferred property, your name, without compensation. So if you transferred it, you don't have it.
Yeah, right.
If you gave it to them.
I was thinking of something today. I saw some guy had exempt on his license plate, and then he put his phone number on, and I was thinking, why couldn't we put in trust on our license plate exempt with our phone number? Because we can bring them into trust anytime that they stop us or do whatever they're going to do with us.
Yeah, but then there's every time they see that, they might stop you to verify whether or not you got it in trust.
Well, what I'm going to put on the back window is do not stop, do not detain, $250,000 fine per 5 minutes if they stop me.
On the license plate?
No, on the back window, so they can read it.
Okay.
That way they're warned.
Yeah, if you can enforce it, yeah, okay.
Well, hey, all they have to do is I'll just take their name and put them down as trustee.
Yeah, you could do that. Yeah.
Well, I think we could have a lot of fun with this.
Yeah, I believe so. Yeah, if we,
Well, that's why I want to go ahead and at first I was just going to stop because I thought, well, we're going to be going ahead with a Sedicate trust, and I'd rather put my money into that area than just try and close out a telephone bill. But then I got to thinking, I might as well go through with it because I've already spent X number of dollars on it, and go ahead and see what the response of Sprint is actually going to be. See,
right.
And then
Because remember that little block diagram I went over with the circle down below, the rectangle?
Yeah.
The general special deposit? You can do each individual title, or you could do it all at once. But like you said, I'd like to see at first we do some individual titles. Since this is all brand new, we don't know if we're missing any steps. And this is a prime example we never thought of. Hey, we didn't withdraw the general deposits in order to make a special deposit. So we need to repeat what we did, and we left that step out, never thinking that we left anything out. And then now, further along into this, we realized, hey, we left some big major step out here.
Yeah, and somebody sharp enough, if they caught that, they would just be sitting back laughing at us and saying, these dummies, what they think they're doing.
I'd rather wait doing it on the major master file when we tried a few individual titles, just to make sure we got the process down right.
Yeah, right. Yeah, it's only going to cost me another $40 for another. Well, actually, it wouldn't have cost me as much as it did, except that I made a couple of mistakes on my UCC1 and UCC3, so I had to do a refiling. The problem with what the filing is, you don't know you made the mistake until after you paid for it, and you can see your mistake because the way you fill in those blanks, it doesn't seem to be making any sense like it does when you can look at the actual form, and then the form comes up after you pay for it. So anyway, I mean, it's so if you made a mistake, you don't catch it sometimes until you're looking at the form. Well, that's $11 right there.
Well, why can't you make out a national form first and then put all the information on there and then put it, in a Word document so you can just do a cut and paste real quick when you file. And that way you've had a national form you're working off of. You can look at before you're filing it.
Well, what I mean is when you're filling out the information, you're filling in like little squares,
What I used to do was I used to create a Word document with all the information on the national form. And all I had to do was then go in and do the filing. I just did a quick copy and paste.
Well, I'm not very good.
I didn't have to type all that information in there. I already had it typed in a Word document, and then I could copy it from the Word document and paste it into their form.
Oh, well, I'm not that good on my computer, so I'd have to learn how to do that. Oh, well, I always have to pay,
But what I did was I just took a national form, filled it all the way out, got all the things the way I wanted it. Then I took I just put like numbers on the blocks. In fact, I think the numbers are already numbered. All I went down on a Word document and put number 1 and then typed in the information. Number 2, typed in the information. 3, on down through until the whole form was done on whatever, say, number 45. And all the information is in a Word document. Then when I do the actual filing online, I got the Word document open, and the collateral block 4, I just copy that and just paste it right into their form.
Oh, okay, I see. Okay.
Sometimes you have only a certain amount of time to fill out these forms before they time out. You end up doing the whole form 3 or 4 times because you weren't fast enough.
Oh, well, Washington isn't that way. At least I haven't had any problem with. I mean, you got plenty of time to work with it. When you're ready to go in, you don't go in till you're ready to go in. But when you do go in, by the time you've figured out and go back and forth and do whatever you're doing, it hasn't timed out on you. And I probably spent 15 minutes, 20 minutes filling it out, so I know it doesn't time out on you. At least it didn't in 15 or 20 minutes.
Some of them do. Some of them do.
Oh, yeah. Well, that's the reason that I stuck with Washington, because I was familiar with it after I went into it.
Right. Okay.
And I called them up and I had some questions for them, and they helped me with the questions. I mean,
didn't you say that also that you could do a correction by faxing it to them? Is that what it was?
well, what you do is if you want to cancel the UCC3 or the UCC1, either one, if you want to cancel it, just email them and they'll cancel it. It'll still be there, but it'll be ineffective. In other words,
you don't have to pay the cancellation fee.
No, you don't have to pay the cancellation fee. There is no cancellation fee with them.
Okay.
It's just an email. Just say, I want to cancel this number, blah, 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 whatever it is.
You don't have to file a termination statement, which would cost you probably.
Right, that would cost you another $11 if you were going to file a termination. But they'll just cancel it for you. But you're the only one that can cancel it, they said.
Okay. Why? Because you're the owner of the document, right?
Yeah, and it still shows that you did that, and it shows that you filled it out, but it's terminated. It's ineffective. It's of no effect.
Mm-hmm.
So,
that's good to know.
But you'll be able to read it for the next 5 years. That you had gone in and done one, but it's not effective.
Okay. So it's clear to you now how to do the extra step there? Just do another UCC3?
I'll just go on my UCC3, and basically in block 4, I'll just title it back to me.
And make it retroactive to the date prior to the first filing of the UCC3.
Yeah. Okay. Alrighty. I think I can figure it out.
Okay. Thanks, Floyd.
You bet. Thank you.
Okay. Anybody else? Question, *6, state your name, where you're from. Anybody else? Question?
Hi, Christian.
Anybody
Hello.
else? Question?
Can you hear me?
Yes. Who's this, Pete?
Hi, Christian. Pete.
Hi,
Yep.
Pete.
There's been a bit of a thing in England where, you know, the aristocracy families, they've served the Queen with Chapter 61 of the 1215 AD Magna Carta.
Okay.
And they're basically going to war with the Queen because she's not protecting the people.
All right.
Yeah, I've just sent Lisa the link. Yeah. So you might want to get some claims ready.
How many people?
I think it was 30.
So what did they do? They did a letter marquee or something?
No,
Declaration of war?
they've done.
What was it?
They've got some type of document made out of like doe hide or something like that. I'm just getting it up now. But it was in the national press. And on the subject of England, while I'm waiting for this to come up, some of the guys in England are fairly desperate to have something of a session.
Yeah, we were going to do one early for them.
Would that be possible?
Yeah. Okay, Pete, press *6. Come on back in.
Yep, thanks. Yeah, I've just found it now. It says, 4 peers invoked ancient rights under the Magna Carta yesterday to petition the Queen to block closer relation with Europe. The Duke of Rutland, Viscount Masserine and Ferrard, Lord Hamilton of Dalzell and Lord Ashbourne were imbued with the spirit of the ancient charter thrust on King John in 1215, in accordance with the Charter's Clause 61, which is lawful rebellion, the famous enforcement clause. The 4 presented a vellum parchment at Buckingham Palace declaring that the ancient rights and freedoms of the British people had to be defended. The clause was one of the most important in the Charter, which was pressed on King John at Runnymede, allows subjects of the realm to present a quorum of 25 barons with a petition, which 4 of their number then have to take to the monarch, who must accept it. It was last used in 1688 at the start of the Glorious Revolution. The 4 peers, who were all thrown out of Parliament in November 1989, proved they had that quorum by presenting Sir Robin Janvrin, the Queen's private secretary, with the petition signed by 28 hereditaries and letters of support from another 60. In addition, they claim the support of thousands of members of the public. They say that several articles in the Treaty of Nice, agreed by Tony Blair in December, will destroy fundamental British liberties. The Queen has 40 days to respond under the Magna Carta's provisions. If the sovereign does not observe the Charter, the people may rise up and wage war on her, seizing castles, lands and possessions until they have redress.
She's got 40 days to respond.
Yeah.
What do you think that she's going to, or what do you think she's going to do? What's the consensus?
Well, she's being touted as being selling the country, selling England by the pound, as it were. And
how's your
and it
credit?
looks like the.
How's your credit?
Well, I'm good.
Yeah. Maybe you can buy about half of England.
Mm.
So they don't make any more
deposit.
land. Yeah.
Yeah. Well, it's kind
Maybe
of
you can
funny
do
because no one knows whether.
Do a settlement against the account and take a trade for the land. Yeah, then you can become a lord. Yeah, a landowner.
I already have it all.
Lord Pete.
Amen.
Maybe you can get free use now instead of
more like it.
Lord Tenant. So. So
Yeah,
what do you
so
think
there's definitely.
They got 40 days, and she's selling off property.
I don't think she's selling it. Oh, what she's done is she sort of give the country away, and it doesn't belong to her.
So she sold something
She's
she had to.
Yeah, she only holds the nation in trust for the people.
So she's royal trustee.
Indeed.
So I wonder if royal trustee has the right to sell the property, but then the proceeds that she got from the sale of the property is really due the people. Where's that at?
She ain't giving that up. They tried to audit, all her things that she owns, and she wouldn't let them.
Well, maybe she can be proven that she commingled funds, and then you could do a tracer on the funds and find out if she did. And if she did, well, she becomes
Ooh.
personally liable.
She does indeed.
Well, the funds were taken by the Bushes, and that's why she's selling off the property now, because she's broke. The Bushes went directly into her private bank account, Coots, and took it out. And that's what's going on right now with she's trying with the Chinese to go after the Bushes to release the funds, which is 5 trillion, something like that, but it's really 14 trillion. So she's selling off the funds or the property now, the assets, so she can keep her little thing going. All you guys have to do is just tell her that she's commingled funds and she's out.
Yeah, breach of trust, commingled equity, gonna presume she's guilty.
Good stuff.
Lewin was talking about that in the practical treatise on law and trust there, but it was one of the royal trustee was not a settled fact that they could bring a claim against the royal trustee, though. I think Lord Hardwick was talking about that.
Yeah, doesn't it say that the ruling sovereign can't be the trustee?
Yeah, but then since then they were made a royal trustee, but then it was that the royal trustee was not alienable to the summons or the subpoena. And it was an unsettled fact, and it still is today, I believe, whether or not she's alienable to the summons or the subpoena.
Because they're her courts, aren't they?
Yeah, I remember whoever it was, Hardwick said that it was a real short arm against the royal trustee, whether or not they had that discretion. So they kind of alluded to the fact that they were too close and they didn't want to really ruin their good position because at that time they probably could have gotten clobbered. So now the times may have changed, and now they could be ripe for some kind of a claim against that for that charge.
Well, she's not the real true queen because, as Pete knows, that their family ties comes from Germany. The real, I think it was Diane. That was the true family that was supposed to be the queen. Correct me if I'm wrong, Pete.
Yeah, I think you're correct. In so much as the lineage queen. From a.
Yeah, she's the colorable queen.
She is, yeah. She is, yeah. The de jure king should be some guy who lives in Australia, if they followed the true family line.
Yeah, because he's the one that wanted to marry.
He doesn't want to do it.
Yeah, but he's the one that wanted to marry that U.S. Is that correct? That was back in. No, I'm wrong. Okay.
So who is now one of the colorable queen? Who would it really be? I mean, not the colorable queen. I mean the real queen. Who would be the real queen now?
Well, it will be the king.
Would be the king?
Yeah. It's a guy who lives in Australia. I think his name's Fawkes.
Why not do a withdrawal of the general deposit of the Queen and her colorable title, and do a redeposit of the private king as a special trust?
What if he doesn't want to be? Because he said he doesn't want to be.
Oh, he's got to disclaim?
Yes.
Well, then he has the right to do an appointment.
Yeah, who's next in line? Maybe he'll appoint Lord Petey.
Well, it's funny because the highest office in England has not been has never been claimed since 1421.
And that is what?
So
County?
maybe that. Sorry.
Something like a county commissioner?
No, I can't remember. It's quite a grand name, you know. Like Lord Most High Treasurer or something like that. I can't remember exactly. Let me have a look. Because they have these strange titles, and when these guys come into power, they like assume a separate office, which, you know, we're told that it's for ceremonial purposes only. But when you read about the actual office, you know, they're acting in two offices, and one must be the feudal side, which I imagine is the substantive side. Are we still on?
Yes, we're still here.
Yep. It says here that the guy, his name is Michael Abney Hastings. He should be the king.
But he doesn't want to be.
He doesn't want to be, no. He said it's too much trouble. He's a forklift driver.
Christian?
Yeah, who's this? Jacob?
Hi, this is Jeff in Washington State.
Hi, Jeff. Go ahead.
I'm thinking that the problem that the Queen has with the Bushes and the Clintons may impact what we're doing, because that is a cabal or clique that is operating beyond the law and has the full support through bribery of the United States government. So it may be that due to their greed, they don't want to allow any of us to grab our accounts. Just something to think about, because the Queen definitely has a problem. The Bushes and the Clintons have stole all our gold. This is discussed in Christopher Story, who is an English journalist, and he's been writing about this for 3 years.
Wow.
And
even if they don't, we still have an IOU that is due to us, and we can still make a claim for it, and there's got to be a paper trail someplace. And if we go to a higher court, if that happens to be an international court or whatever, they're still answerable for the claim.
Well, they haven't helped the Chinese and the Queen. The Chinese have a lien on our U.S. Treasury, and essentially our military told them, no way.
Mm-hmm. Well, this looks like the solution that the Antichrist is going to come up with for the problem here that's being created.
Yeah, we'll probably have to go that route to get our remedy, because it's going to be a big war.
That's what's up and coming, yes. That's what Revelation tells me.
Yeah.
So, Pete, Go ahead, continue on.
Yes, then the other thing was to organise maybe a little group event with the English. Oh, actually, I've just found the position of Lord High Steward of England is the first of the great offices of state. The office has generally remained vacant since 1421, except at coronations during the trials of peers in the House of Lords, when the Lord High Steward presides. In general, the Lord Chancellor was appointed to act as Lord High Steward in the latter situation. The trial of peers by their peers in the House of Lords was abolished in 1948, although trials on impeachment have not been abolished, though long obsolete. There was a court of the Lord High Steward which served this purpose when Parliament was not in session. And that's on Wikipedia. It goes on a little bit more in detail there. Quite interesting. Yeah, so if we could organise a meet for the English, that'd be fantastic. Maybe late at night here and somewhere around early evening time, Pacific time.
Yeah, what day?
Thursday? Could you make Thursday?
Might be better early next week. Monday or
Okay.
Tuesday.
Well, I know they're desperate, so I'll put Monday to them, and see how many we round up for that day, and then should we call it Monday then for now?
Yeah, Monday looks better.
Yeah, brilliant.
What time?
What time? 6 p.m. EST, something like that. 5 p.m., 6 p.m.
6 would be okay. Yeah.
6, yeah, that'll be like 11 p.m. here. Should be okay.
All right, so 6 p.m. Eastern, Monday.
Right, yeah, thanks very much, Christian. I know everyone will appreciate it greatly, and they'll be very, how can I say, orderly and, well behaved.
Christian? Pete?
Yeah.
Yeah,
Go
this
ahead.
is Bill from New Jersey. How you doing?
All right.
Good. Pete, there was a show in England about the real government, the bureaucracy. I forgot the name of it. But it seems to me we were talking last night about, private banking. Well, the Queen is the co-oval ruler, but actually she's a figurehead for the private government. So, it occurred to me maybe the people to target would be the administrators. You can subpoena them, not so much the so-called royal queen, and maybe you could get remedy for it.
Maybe we could do what now?
In other words, see, it's not so much the person up front, the queen. She's protected. It's uncertain whether or not you can subpoena the queen, but you can subpoena her officials. The people in the government who actually run the government. The queen doesn't run the government. The people you want are the people who actually make those deals. Who is the Grand Exchequer, whatever the title is? That's the guy you want. Those are the guys that actually do the deals. Those are the guys that make the deals happen to sell or to buy. It's in the Queen's name, maybe, but she's just a figurehead.
Right, it really comes down to is why would we want anything out of the public? It's all fiction anyway. So why would we buy a pig in a poke?
That's what I'm saying. You don't deal with the Queen, you deal with the people like private banking, the unseen people, the guys who don't show up. Those are the guys
but
who
even
really
this private banking stuff is really fictional in itself.
Mm-hmm.
And really, why do we even want a part of that?
But what's the
It comes
difference?
back down to they owe us, or they owe the English people, whoever, they owe them. But what do they owe them? Are they going to get the same thing they deposited in back? No, they're going to try to give them some kind of conversion to some kind of fictional currency. I don't want that crap.
Right, but I was just talking about jurisdiction, about if there's a problem with initiating a claim against the royal family.
Yeah, that's what I was kind of telling Pete. Really, what you really want is you want substance, and land is substance.
Mm-hmm.
This fictional stuff of bonds and notes and things. No, I don't want any of that stuff. Give me something of substance.
Yeah, they're going to try and do the same thing over here when we go in and tell them we're closing down our account. They're going to try and give us something else instead of the real thing.
Mm-hmm.
No, you don't. The Queen is the one that you go after. She has all these other people around her trying to protect her. You go to the top dog. You don't go to the cronies, because all they're going to do is send you over to this office or this agency or wherever the case may be. You get a hold of her because she's the one that's holding the title. Bunch of co-trustees underneath of her, but you get her attention.
Yeah.
Hello, Christian.
Yes, who's this?
Hi, this is Dan from California.
Hi, go ahead.
Hi. Yeah, I'll just real quick. What were the books of interest that you were looking into in the Corpus Juris Secundum? Which volumes were you most interested in?
Well, the one under banking, bank and banking, which was let's see, where's my book at? That's a good place to start because that's where deposits, under that section for deposits.
Okay. Well, there must be something special in those volumes, because on Thomson West, that whole collection is about $8,400.
Yeah, right. Also, the book on equity, which was 30A.
Okay.
The banks and banking was on number 9.
Okay.
And I started under deposits, and that was I forget what section that was. And then the next one I would go into would probably be the Guardian and Ward, which is book 39.
Okay.
Now I forget the publication dates of those, the copyrights, but they may have different numbers on them now for some newer ones, depending which one you're looking in.
Yeah.
But bank, equity, and Guardian and Ward. And then you could look up like depositaries is another one, bills and notes, suretyship. And when you start digging in one, it'll lead you to another, because this stuff is construed all through it, all the different volumes.
Now, as far as the volumes go, are they like a quotable, reliable authority that you put in any documents, or is it just simply a reference type document?
No, it's the body of actual law. And then on the footnotes it gives you actual case sites to support, it's the substantive, it's the substance of the law.
Okay. Great. Well, there's a nice big law library in downtown LA. I'm sure they have the whole volume.
Yeah, and then maybe check out AmJur also and see how that comports with corpus juris.
Is American jurisprudence closely related as far as the purpose of that volume?
Yeah, they're very similar. I understand. Yeah.
That's a lot. That's a lot of reading between those two volumes.
Yeah, but really it's hidden because I see a very small amount of golds. It's the wheat and the chaff mixed up, but the wheat is there. Most of it's chaff, and the chaff is really the general deposits. The wheat is the special deposits. The special. Every place where it says special, because it's special versus general. Watch out for the wording. The general is really a general deposit. The special is a special deposit. Or it gives reference to certain circumstances. Well, what kind of circumstances? Well, there are general circumstances and there are special circumstances. And it ties in with Black's law under the definition of special. Because if you look in Black's law, it lists special this, special that, special this, and that's all that we have. Now, that's all the special deposits, special whatever. That's the private side. And it's all through this of body of law, whether it be AmJur, I'll bet you, or corpus juris secundum. And it starts forming a pattern because there's only one thing under trust, and that's special, and that's the private side. That's all there is. And all the rest is general. And it's all the 63 million codes and statutes and codes and things which they really don't mean crap. But through sifting through this stuff, you're going to pick up the verbiage. And it's just like the movie Matrix. When Neo, at the end of the movie, he could read and write the code. He saw the walls and the ceiling and the floor and everything was the code. But that was before he went into the agent. He could... or after he got shot there, and he believed that he was alive still, but then he went into the agent. That was the merger right there.
Right. And maybe getting shot and dying was symbolic of losing in court or getting your ass handed to you one way or another in the public.
Could be, yeah, but it was a realization that I don't... it's just like in the movie The Wizard of Oz. She had the power all along. She just finally realized it right then and there.
Right. And
the good witch told her at the end, I could have told you the beginning, but you would have never believed me.
Right.
Neo had to do the jump. Well, at least he tried. He wasn't successful at it. But at least he did the jump. And he did the fight scene in the train station, and he started to believe at that point. Instead of running. Then he did the thing on top of the tower there where he saved Morpheus, and through that point, he was starting to believe what they were telling him all along, that he was the one. And it's all coming back down to the spoon. There is no spoon. You got to bend your mind. You're trying to tell me I can dodge bullets? No. When the time comes, you won't have to. When you can read and write the code, you're in control of the whole situation, knowing that you have all the power. And really, I'm starting to see that the power is equity, but where's equity? Equity's in us. We are equity. We're just not giving the orders believing that we are equity.
Well, when you're born into a construct that you just take as reality. You know, you're given one piece to the jigsaw puzzle, and then all the other pieces have been hidden, and it's like, go find them and put them together.
Yeah, through the social conditioning, we've been taught to believe a certain way. But now when you read corpus juris secundum, you can pick out the one side versus the other because the way it's written simultaneous with the duality already right in it. You just have to be able to decipher the substantive side from the general side. The substantive side being the special.
Now, I was listening to the call last night, and you had mentioned the idea that the process was being done backwards, and that losing publicly in court would somehow open the door to equity. Should a case be lost in the public through an outlaw process, would possibly getting into equity involve a private correspondence with the judge, sending him a letter saying something like, you know, I didn't receive my remedy at law, and now I'm invoking the chancery or equity to wrong a right or right a wrong.
Yeah, but that would probably have to be a colorable motion back on the public side.
Right.
You got to be in control of both sides simultaneously. So you got to get some kind of documentation order to the public side, along with the documentation necessary for the private side.
But now, if you were to lose in the public colorably, but then win in the private, would that not somehow raise suspicion from your opponents, whoever, mortgage company or whoever they might be?
It might raise suspicions, but they really can't question, because in Lewin it says on page 19 of the book there, Practical Treatise on the Law and Trust, that if there's any conflict between common law and equity, equity rules.
Right. Okay. But I guess
so your equity is going to look through the form or the process and procedure. It's going to look through into the substance and reveal it for what its real nature is. So these general deposits is the cloak that is hiding another type of transaction, which is the special deposit. And equity is going to look through the form into the substance and reveal its true nature, which is the law of nature, which was equity. The law of nature, and the nature is God. That's equity. Equitable principles. Based on maxims. So it's the maxims that we really have to get a better grip on, and those maxims are listed under the book on equity there. And knowing how to apply those maxims.
I found about 17 of them online. Are there a lot more than that somewhere else?
If you get a Black's Law in the back of the book that lists the maxims.
Oh, they're in the back of Black's Law. Okay, great. And also, is there an ambassador group in California that you're aware of? Or at least a group that I may not necessarily need to
Chris
be in.
Summers in California, and I think Jacob's in California.
Oh, okay. I don't know.
And I forget who else is in California. Somebody else too. Carlos. Carlos is in California.
Is there a forum or some way to throw that out there as far as me getting together with a group for discussion or study?
If those people are on tonight, maybe they'll come on and do a Skype name or something.
Right. Well, if they're not on, I'll just come on another call.
Yeah, do that.
Now, real quick, I also intercepted, I was party to an email that was sent to me in response to, I guess there's some guys doing some stuff, Restore America or something or other. They're using, I think they're using biblical trust to establish their sovereignty or something like that. And they received an email from a retired judge, and what he said was the reason no one can borrow money against land in the U.S. is because of fee simple deeds. These deeds converted all land into chattel promised to the board of the Federal Reserve Bank to guarantee repayment of the federal debt. All registered owners of land were converted into tenants on the land. So
you're correct.
He's basically saying you can't do anything until you can provide a allodial title, and all the fee simple deeds must be challenged in the courts. So this is coming from a judge, and it sounds like it was written by a judge based on the language. So.
Mm-hmm. But it's all done under misconstruement.
Right.
And the grantor can come in and claim and do the correction on it.
And then to be able to do something like that, we would need to be competent enough to draft our own indenture at will, right? Is that basically where this is going?
No, it says it's extinguishing the simple contract, which is the debtor-creditor, in the higher security, which is the trust, merging the titles and extinguishing the debt.
Right.
When you merge the titles, that terminates the trust and allows the perfect title to come forward, because now the perfect title is not held in trust. You can't get an allodial title or perfect title today because of the trust. The trust is holding it back. Split the titles.
So, merging title is typically the desired outcome as far as making a payment.
Yeah, because the merging of the titles is the extinguishment of the debt. It acts as the payment.
Could you assign partial title to multiple trustees?
If I was trustee, yes. Then we'd take a consensus of all of them to do something, though. They all want a part of it.
And now,
or if it was on a beneficial interest, there might be multiple co-beneficiaries. Then it would take a consensus of all the beneficiaries to transfer the beneficial interest or do something as a claim-wise. Depends which title you're talking about.
Legal title, I guess, would be the trustees. What they usually hold is legal title, right? The trustee.
Yeah, right. But it's just like the definition of merger in Black's law.
It becomes a higher form of what once was, right? Basically, is what the
right. Extinguishment of the lower and the higher.
Right. Oh yeah, I had one quick question. Let's say a typical at-law cause of action, like breach of contract among private individuals. Like I have a construction company, and the general contractor that I was doing the job for stopped receiving funding from the bank that financed the construction project. So now, at law, I've got a breach of contract cause of action because my contract was with the general contractor and he's not paying. Through no fault of his own, the lender simply stopped distributing funds. But is there, on a private contract like that, is that something we could turn into a trust, turn the contract into trust res, and make the contractor and the bank both trustees, and come in as a grantor beneficiary?
Yeah, I don't know the details exactly, but you could always go back in where the original signing of the contract was. Instead of treating it as a contract, treat it as a trust.
Right. Well, it's pretty simple. We've completed a construction project, and we're waiting for the final retention payment, and the bank simply just stopped funding the thing, and now the general contractor, with whom I have a contract, is not paying as a result, and that's pretty much as simple as that. That's pretty much what it boils
So what
down
is he doing?
Well, he's given us the runaround because other subcontractors are obviously in the same boat that I'm in, and he's just kind of burying his head in the sand, hoping nobody files suit or whatever. And he's not.
What's he doing against the bank that they won't pay him?
He's claimed he's retained an attorney to potentially begin a lawsuit, but he's a shifty guy, and I can't rely on him to get a straight answer. So. But we've done quite a bit of work with this guy over the years, and I kind of don't want to,
How do you know? How do you know it's not him and the bank did pay him?
Exactly. So
because I used to be a contractor in California too, and it sounds like the same thing occurred to me, and I just leaned up the whole project.
Yeah, I got a mechanics lien on file, but it expires in 3 months, so I'm not exactly.
Maybe you better look at a higher lien position.
Yeah, do a maritime lien. What type of project was it, or is it like a storefront, or what was it?
No, it was a mixed-use building in downtown San Pedro, right there on the harbor. It's pretty much retail on the first floor and some condo loft-type units on the upper floors. Pretty good.
So it's condos, so people are living there, right?
Well, what's happened is since the bank has stopped funding the project, everyone's leaned up the job, and also the builder / contractor is claiming that even though the builder had buyers to come in and purchase up most of those lofts, the bank has refused even to accept those new buyers as people buying into that property. And according to this guy, the bank has simply just stopped everything. That they won't allow the contractor to sell any units, and they're not distributing any construction funds that are still pending. So. Who do I believe? I don't know, but I figure just name them both as trustee and co-trustee, and let equity sort it out. I'd imagine the contract has my signature on it. I'm obviously the grantor of that contract, so if that's something that can be put on a UCC-1, the contract itself, and then assign it to them on a 3. Right. I guess we'd form a trust through transfer and delivery, I'd imagine.
Right.
Or pull that contract out of a special deposit, like pull it out of a general deposit and redeposit it to him as a special trust deposit.
Yeah, that's basically what you're going to have to do. Yeah.
I guess my question was, since it's through 2 private parties, I'm not dealing with a bank per se. I'm dealing with a private guy. I was just wondering if the same process holds true on a man-to-man basis instead of man-to-fiction basis.
Yeah, same thing. Trust is trust.
Trust is trust. Okay. Well, that's all I had. Thank you.
Okay, another question, anybody?
Tammy here.
Hi, Tammy.
Hi.
What have you found tonight?
Oh, I found some good stuff in this Amder 2nd edition. And just a note to wise to that guy that was just on to start its process and don't be afraid of going to court, because that's what will end up happening. He needs to state his claim. But anyways, in Amder, again, I found there was only like 4 pages under the banks section that talked about special deposits versus general, and they actually have a form 47 that's entitled complaint, petition, or declaration to recover special deposit from which designated payments were to be made, other funds used for payments. But what I found was most interesting in the first paragraph, it says that defendant is, and at all times herein mentioned, was, comma, a corporation duly organized and existing under and by virtue of the national banking laws of the, get this, United States of America, comma. The first time I've ever seen that shit. The word of America within these books, okay? With its principal place of business, and then it goes on, and then the second page is, let's see, and it ends with the caption of actions to recover special deposits, 10 Amger the second under banks, whatever them two squiggly oversized S's are, 360 to 368, comma 449. And then the one I talked about the other night goes on into the cattle one, but it's just amazing that there was only like 4 pages, but there's 4 good pages of, you know, sample pleadings, you know, about special deposits. So I just wanted to bring that up, and I started delving into the other thing we were talking about with the Guardian thing, and that's got a lot more stuff, but I thought that was a cool find too, and I think there.
Is there anything on there in the set there with breach of trust?
Within the other one, the ad item thing, or the, I'll look for breach, yeah.
Yeah, breach of trust.
Yeah, I just delved into this a little bit, got out my ink pen and underliner, and, you know, did some of that, but I'll delve into the other one a little bit tomorrow, but
Or it might be under causes of action.
Causes of action.
For breach of trust.
Okay, yeah. Get this, I went on the internet today looking for some more, you know, of the Corpus Juris books and stuff, and I happened to realize that my volume of Amger books here that I spent $50 on are online for $9,000, and I'm like, woohoo! That's kind of exciting. Like, dang, my books have appreciated in value.
Yeah.
Kind of funny.
Good
Anyway,
investment.
I thought I'd share that, so there's some more backup, and so there you go. I got to call it an early night tonight. So I get up early. I fed my chickens, my 75 chickens, and my 6 turkeys. So I'm out. You guys take care.
Okay, thanks.
All right, thanks.
Yeah, Christian, Floyd again.
Hi, Floyd. Go ahead.
Hi. I've been reading this UCC 3 amendment, and I've been trying to figure out here, in Block 8, I can do an assignment, a partial assignment. So I was wondering, do I keep the changed name on my UCC 3 that I'm filing now back to me? Do I keep the individual's name that I have in there on this one the same, and then just go into the Block 8 and say something like, with all attachments and proceeds therefrom are hereby fully transferred, with the exception of transferring back to something like that. I'm not quite sure how to say that.
No, I want full transfer each way.
Full transfer each way. Okay. So then, instead of his name on the next UCC 3, I'd put my name as the changed name.
Your name is the changed name. All right, we're at now?
Yeah, okay, this is the way it looks right now. The initial financing statement is 2010-134-5669-7. And this UCC 3 number is 2010-134-5703-8. And the changed name is Robert Brust. He's now the trustee. And would I put my name there then as trustee, and then
Oh, he's got your name as trustee, and your name stays the same. You're just transferred from the trustee back to you.
Okay, so then what would I put in Block 8 then? Because right now it reads, this is actual and public notice by grantor as owner and holder of all rights, title, interest, with a non-negotiable instrument claim number, RA, blah, blah, US, with all attachments and proceeds therefrom are hereby fully transferred. Would I say are hereby fully transferred back to Nunk-Pro-Tunk, the original owner, or something like that?
Let's see. I might have to look at the form. Maybe you might have to switch the names now that I'm thinking about it.
Well, I could make a note in the collateral change. If I did that, I could say I could say with the individuals. If my name was in place of his, I could say the attachments and proceeds are hereby fully transferred Nunk-Pro-Tunk in reference to filing file number 2010-134-5703-8 or something like that. In other words, I could say that the attachments, that all of the transfers that were made are now transferred back before this transfer was made. And then this transfer then would remain viable, because that transfer was made. This transfer would be made after my transfer was made, even though my transfer was made after this one. Is that confusing enough?
Yeah.
Oh, well, in other words, once I do a Nunk-Pro-Tunk, a transfer back Nunk-Pro-Tunk, that filing now supersedes this filing. So, but this filing was made, even though before the one that was made Nunk-Pro-Tunk, it still would follow. It would still follow that filing legally.
I'm thinking that the trustee position don't change. It's just the transfer took place from him to you. It might be just in the verbiage. You might have to change the verbiage around in the collateral block. And your collateral block is block 8?
Yeah.
Okay.
Yeah, that's on the amendment. That's on UCC 3.
Okay.
Because on UCC 1, it's 4.
It's 4. Yeah.
Yeah. So if I say something like all attachments and proceeds therefrom are hereby fully transferred Nunk-Pro-Tunk filing number 2010.
Yeah, I think the transfer on the 3, they're assuming that it goes from one party to the other. How do they have the party set up? Which one's first? The secured party first?
Yeah, no, the secured party is in block 9, showing that that would be the grantor or the assigner. Actually, that same thing, grantor, assigner, because the assignee.
From the grantor to the grantee being trustee.
Yes, see, I would be showing myself in as the secured party, giving myself as trustee. In other words, making myself trustee of the, because you can be grantor trustee.
Yeah,
so
I think you want to switch the positions of the names. And that would probably solve the problem.
Yeah, I would just put my name in place of his, and then in the amendment part, I would put all proceeds therefrom are hereby fully transferred nunc pro tunc of the filing file number 2010-134-57038. Would that do it? Okay.
I think so, yeah.
Yeah, okay. I'll do that then. And then that way, that shows that filing now supersedes.
That one's identifying it that came before the first one, which now this one becomes the first one. The first one becomes the...
Yes, right. Okay. All right. I'll do that then. Very good. Oh. Well, if you have any more questions,
you know, I would put on the collateral block on that one you're doing now. I would make reference to the as it being a general deposit is transferred.
Okay, let's see. Okay, all attachments and proceeds therefrom are hereby fully transferred nunc pro tunc as from general deposit to special deposit.
Well, no, it wouldn't be a special deposit because you're transferring it back to you. You're not doing a special deposit in yourself. So you're just reversing it from a general deposit in them back to you.
Oh, okay. From them to me. Okay. Well, when you say them,
withdrawal of general deposit. Withdrawal of general deposit.
Okay, let me get this. Okay, with all attachments and proceeds therefrom are hereby fully transferred as general deposit.
As a withdrawal of general deposit.
As a withdrawal of general deposit. Okay. As a withdrawal of general deposit. Okay. Okay, yeah, that would identify the transaction then.
Okay, so read the verbiage again.
This is actual and public notice by grantor as owner and holder of all rights, title, and interest with the non-negotiable instrument claim number RA blah blah US, with all attachments and proceeds therefrom are hereby fully transferred from a nunc pro tunc 2010-134-5703-8 from general deposit
No, you missed some.
What did I miss?
From withdrawal of general deposit.
Oh. Okay. Let me just hang on a second here. I'm going to get a piece of paper. Okay. Are fully transferred. From, let's see, are fully transferred nunc pro tunc
It's as withdrawal from general deposit.
Say that again.
As withdrawal from general deposit.
As withdrawal. General deposit. Let's see, there's fully transferred as withdrawal from general deposit to I lost it now. So can you help me out?
Okay, read it again.
Okay. This is actual and public notice by grantor as owner and holder of all rights, title, and interest with a non-negotiable instrument claim number RA blah blah US with all attachments and proceeds therefrom are hereby fully transferred non-pro-tunc as withdrawal from general deposit as general deposit in regard to file number 2010-134-5703-8.
Okay, read it again, but don't read it smoothly.
Okay, this is actual and public notice by grantor as owner and holder of all rights, title, and interest with a non-negotiable instrument claim number RA blah blah US with all attachments and proceeds therefrom are hereby fully transferred non-pro-tunc as withdrawal from general deposit in reference to 2010 filing 2010-134-5703-8.
And that's your previous UCC, or your first UCC to 1 or 3, I mean.
Yes.
Read the last part again. That as withdrawal, what?
Let's see. Transferred non-pro-tunc as withdrawal from general deposit in regard to 2010-134-5703-8.
Okay, not in regards to. Put it in there prior to.
Oh, prior to. Well, that's what non-pro-tunc is, isn't it?
Yeah.
Okay, but that's
all the way back. Yeah.
Okay. 2010-134. To filing.
Take out non-pro-tunc and put it where you're going to put the prior to then.
Okay, transferred. Okay, let me see. Transferred prior to as withdrawal from general deposit non-pro-tunc filing number 2010. No.
So let's change non-pro-tunc to that other word, prior to. And then take out that first prior to.
Okay, just put non-pro-tunc twice?
No. Take out all the non-pro-tuncs.
Okay.
Oh, and then replace non-pro-tunc, the last one you put in there that you changed.
In other words,
that prior to. Take out the first non-pro-tunc. Take out that one when you just changed it to prior to. The first one.
Oh, change the first non-pro-tunc to prior to?
No, take out the first non-pro-tunc altogether.
Okay.
Now, the second non-pro-tunc, change it to prior to.
Okay. All right, so then that reads transfer.
Now read it again. Read it again.
Okay. Transferred prior to.
No, take out that prior to. Take it out.
Oh. Well, then what do I put in there? Do I put in?
Read it without the prior to, first prior to, which was replacing the first non-pro-tunc. Take that out. Now read it again.
Okay, transferred as withdrawal. Let me see here. Proceeds, therefore, from are hereby fully transferred as withdrawal from general deposit prior to 2010-134.
Good.
That sound okay?
Yeah. Now read it all again. The whole thing.
Okay, this is actual and public notice by grantor as owner and holder of all rights, title, and interest with the non-negotiable instrument claim number, RA, blah, blah, with all attachments and proceeds therefrom are hereby fully transferred as withdrawal from general deposit prior to 2010-134-57038.
You got it.
Okay. Very good. Thank you. Okay. Well, I'm gonna file this thing tonight before it gets cold. So.
All right. It's all warmed up now.
Yeah, I'm warmed up now, and as long as I'm concentrating on it right now, and I've got it in my mind, and my scribbly notes, I can make them out. So tomorrow I won't be able to do it. So I'm going to do it right now.
Okay. All right.
Okay. Thank you.
Hi, Christian.
Hey, go ahead. Who's this?
This is John in Boston.
Go ahead, Tom.
I had a question about a remedy in the public to do with exhausting that remedy. At what point are we satisfied that we've exhausted our remedy?
On the private side?
On the public side.
On the public side. When you lost, you've exhausted your remedy on the at-law side.
Yeah. So would you? I mean, what would happen if we appealed? You know, how high could we go before we were satisfied?
Well, I'd say that the fact that you say you are appealing, that tells me you have a loss, right? So.
Right. Okay. And so then after that, then you would go into the private side and do your administration there.
Yeah. That's.
So, with that in mind, is it still appropriate to use these techniques that you've been talking about, where you claim an asset title to merge with a debt title before we go into the public and lose?
Yeah, that would have the information that you're claiming, so you can prove it when you're in there.
Oh, okay. So it's still appropriate to do that paperwork beforehand, then come in the
right.
public side.
That would be completing your administrative remedy on the private side.
So would we do that before or after we try the public side?
Well, you should have it probably completed before you go into the court of equity.
Right. Okay. Yeah. Makes sense. Yeah, I just wanted to clear that up. Thanks very much.
Because the private side would be the trust, claiming the trust and proving the trust, and then once you prove the trust, then you can make a claim for, say, the breach, and then use the merging of the titles to extinguish the debt. And that would be the real nature of the whole thing, because it's all trust.
Yep.
And that would look through the at-law side judgment and reveal it for what it really is in the private, the real substance.
Yeah.
The real nature of the thing.
Perfect.
The at-law side would be the lower form of law compared to the equitable side.
Yeah.
And now you lost your first stab at the apple, so to speak, and then you can go into equity, and equity's going to look right at the truth.
Yeah, that's brilliant.
Anything
Yeah,
else?
thank you. That's it for the moment. Thanks very much for clearing that up. Thank you.
Okay, another question, anybody?
Hey, Christian.
Who's this?
Shane from Hamilton. How you doing?
How you doing?
Pretty good, pretty good. Just general question. If I was just listening to talking to Floyd there, and I think we've got it kind of set up now with that three-step, the UCC1 and the UCC3 for transfer, withdrawal of general deposit, and then another UCC transfer is deposit, or transfer as special deposit. I was just thinking more of a general question. If you got into a situation where generally, I shouldn't say in general, but let's say you basically want to demand the original signature document. Because actually, as I was listening to what Floyd was saying, it kind of popped another question in my head. Is it necessary to demand the actual physical document, or it's almost in a way, like you're saying, through the UCC3 in that particular example, that would be good enough, just a notice of your intention of what is essentially a transfer for the purpose of withdrawal of the general deposit. So I guess, well, my first question is what I was going to originally ask you is, when we demand the original signature document, are we not, that's a really, I like it because you could do that for any reason, so it could fit colorably or otherwise. But in the act of even doing that, is that not kind of creating, by implication, and exposing the whole trust element?
Exposing it how? On what?
Well, because then it puts an onus on them to either assist you, by providing the document, or refusing to. And if they refuse to, would we not be able to go after them for breach of trust?
Well, if they refuse to give the document, they were the trust res that I signed on the second UCC3 that transferred it to them as special deposit. If I don't get those documents back, or they're used for the specific purpose that was set out for, then they would be in breach of trust.
So in a real simple scenario, where somebody just says, that's it, I'm putting my foot down, I want the original signature document before I go any further on any of this. Something like that, you know what I mean? On no purgatory language.
On the first one, you mean? We want original signatures back on the first one? On the first three?
Yeah, like I'm not even talking about UCC right now. I mean just in general, in any kind of situation, because stuff always comes up. They always lay trips on you for all kinds of things, this, that, and the other. Right at some point, you just say, okay, this is, you might get the impression they're not listening or paying attention or working their angle or whatever, and you just say, okay, you know what? I want the original signature document. I just like it because it's straightforward. It's very hard for them to pretend they don't understand English. It's, I like stuff that's...
That's the next question? When they don't do it, what's next?
Yeah, I mean, technically, obviously, they're going to try and make up all manner of excuses again. This is predictable. And then at that point...
Scenario, just the way you explain it just right now. So I want to get a document back from general deposit. The only way I'm going to get it back is if I create records that I've transferred it back. And the records would be the proof of my manifested intent that they were mine and I wanted them back and I gave an order that they're back. The fact that you still retain them and hold them does not make you the owner because I've transferred ownership from you to me. Even though you are holding the documents, you no longer have title to them. Now I can come at you under equity for a breach of equitable interest because you haven't given me my equitable interest back. And I don't have to do that under trust. I can just do that in equity.
Okay, sorry. You were referring to yourself as me there, as the party trying to get the document back, trying to get the original signature document back.
Yes. Now, the fact that you don't return the document still does not reflect the fact that I have transferred ownership from you back to me. It's mine. I got title to it. The fact that I have title to it and I have actual records to prove that now, the UCC transferring it back to me, and my claim that I claimed it. Now I can come into a court of equity and come at you just in equity and force you to give me my titles back. The actual doc.
So you're going back saying that your strength of position lies in that UCC1 as notice of claim and the follow-up UCC3. And we don't even have to get to the second UCC3 yet. But the UCC3
I'm not
is
transferring the actual paper. I'm transferring the title to the paper.
Right. I got to stop thinking so literal sometimes. So yeah, we're just talking about title.
Paper, but that's not possession. Is not title.
Physical possession is not title. What you're saying?
No, possession of the certificate of title is possession. The possessory title.
Right. Okay. So now, in this case,
I gave them my signature on those documents. I also transferred, not knowing, I transferred title to them of those documents.
Right. By how you signed.
Two different things. Possession of the actual documents, I gave it to them. Plus, I also transferred title. Two different things.
Yes.
Now,
I see that now.
I can transfer what I gave to you, the title, back to me, even though you're retaining the actual possession of the documents, is two different issues. You are holding documents, but I have transferred ownership back to me. I've transferred title. Now, I can enforce title and get my possession back.
Gotcha. Okay, so there is an order of operations there. I do want to do the UCC 1 and 3 first to establish that in the case of a question of misunderstanding or proof of some kind of evidence to back up my...
What kind of evidence do they have that they have title? Holding?
Well, they have the evidence.
Title, which is transferred and claiming, and I got actual documents to prove that. That's the manifest of my intent, that it's been transferred.
That makes sense, because I have to overcome what they have, which is the actual physical possession, and by the way I signed the signature, the presumption is that they have the legal title as well.
By presumption, yes. Now I've got documents to make that presumption. Actual records.
Exactly. Gotcha.
And I can go into a court of equity and really get them for the possession, because now they must transfer possession of the property back to me because I have title. Kind of like a quiet title action.
By virtue of the UCC 1 and the 3?
Yes.
All right. Okay. So then I would in a more practical circumstance, I would make sure I have those things done in my little file. Okay, I'm demanding that, and then when they don't, I could at that point I could go after them, and I might want to create some opportunity to go in private chambers to show those documents to the judge?
Yes, because that's my evidence that I have title.
Yeah, okay. And that would be a nice way to do it, like on the private side like that?
Uh-huh. because it's all done through equity.
Now, if you're in a communication with a large corporate entity, like these all these places that bill us, is there anything we can say to them to give them a hint or indication where we're coming from? So, like, we don't always have to, going to court and having your documents at hand and being ready to present them in chambers is the insurance, absolutely. But is there a quicker way we can relay our intentions through some kind of written correspondence directly with the, let's say it was a credit card company or a biller or your hydro or whatever?
Okay, you want to...
In other words, can we let them know we're making financial statements, make reference? Well, I'll be doing some financial statements to make sure I get back my control, understand I'm operating in some kind of trust capacity. I'm just trying to figure out how much we can say to them without ourselves violating, because we got to be careful we're not reaching our own trust by speaking about it publicly, right?
Yes, but if we're privately talking between two parties, that, I can tell them, hey, this is a trust, because we got a private agreement between the two of us, the credit card company. And
yeah.
I'm not really afraid of. Although I want to specify that they're supposed to keep this confidential now.
Sure, and I guess I could fix all that just as simple as putting it without prejudice on any correspondence with them, and in confidence or private.
Right, confidential, right.
Okay, yeah, that's starting to make sense. Just trying to get a little practical picture.
Now, let's take that little scenario that we talked about just earlier there, transferring the title back to you. You want the actual documents. Let's say that I just want to do the second three and transfer and form the trust deposit by special deposit, and now I really don't want those documents back because those documents become the actual special deposit.
Right. Well, okay, yeah, you kind of... you changed my whole context there because, I was thinking of those documents in the physical sense, and you've clarified again, there's physical possession and then there's the legal title possession. And, even if I did get them physically, I guess I'd be saying, I would literally have to be saying, well, I want you to take them back now.
The type of titles in the first scenario was talking about the legal title or possessory title. But on the second UCC3, now we're talking about a different kind of title because it switches from general deposit, which is possessory title, it switches now to special deposit and beneficial interest title.
Actually, there's a question.
What's the whole nature of the titles? By pulling out of special and pulling it out of general and putting it in the special. We change the whole nature, character of the titles.
No, that's a beautiful focus, and we have to have, absolutely. Got to keep that clear. We all have to keep that clear as fundamental. Basically the purpose, pulling out a general deposit, going into special deposit. Now, if in that scenario, that wonderful hypothetical there, I get the physical ownership. I'm not so concerned about it now because now I'm separating in my mind the difference between physical possession and legal possession of title. So now let's just say I do have it though. And I remember now you're making me think of going back to when we were trying to, we were talking about who keeps the originals and who keeps copies. Technically, at that point, let's just say I forced them to give it to me and I'm holding it in my hand. Would could I still do the transfer, the UCC one as notice of claim, and the UCC3 as transfer and withdrawal of general deposit, and then say something like, well, you know what, I'm going to keep these, the originals, and give you copies. So technically the special deposit itself is really more of a concept. It doesn't matter whether I'm holding it or they're holding it. That's sort of my question. Or is there an issue that this special deposit is more of the idea of where the actual original documents are? I can have them in any kind of place of safekeeping. I'm just curious there, since we got there. Does that make sense?
Yeah, I'm trying to think if it was,
I mean, it may be better that they have it in terms of liability, but if so,
wanted to do with it, if it was for a specific purpose of maybe they have to convert it, then you may have to give them the original, say, equitable asset so they can convert it.
yeah, okay, yeah, which makes sense. That makes sense, yeah. So they might actually need it, and so I just need some kind of a certified copy then.
Mm-hmm.
Right, because that's, in that sense, it's a kind of an instrument. It's a trust instrument.
Right.
Okay.
Special deposit, trust res, yeah. Equitable asset.
That incredible fine line. You can almost see how the two superimpose the, you know, as I was going to say, a
they're all
financial
functional,
instrument.
but we don't separate them according to, say, beneficial title and legal title. We think
Well,
all
not
titles.
just that. Not just that, but looking at it as a trust instrument versus a financial instrument, and we got to be careful not to call it. That whole financial instrument, debit credit picture could fit right on there. They still need it, you know, to convert it and so on. But it's also a trust instrument. There's that
because the
superimposition.
relationship looks so close, whether or not it's trust or whether it's debtor creditor, that you can't tell unless you go through the elements and find out which one's missing.
Yeah, that's how they hide it.
Character and nature of the whole relationship.
I got a technical question. This is Floyd.
Yeah, Floyd. Yeah.
Okay, am I amending the UCC3 or am I amending the UCC1?
The three.
The 3. Okay. So they're asking for a file number here, and I want to make sure that I put in either the UCC1 or the UCC3. So I need to put in the UCC3 then.
Right.
Okay.
Yeah, traditionally UCC3 can be used as an amendment as well, right?
Yes.
Okay.
Use the addendum, amendment, or transfer, or.
Yeah, I still want to get with you on that, Floyd.
What did you say, Shane?
So I still want to get with you on that, Floyd. I've just been caught up on a lot of things.
Oh, okay. Well, I've been real busy, so sometimes I'm here and sometimes I'm in my garden.
There you go. That's all of us.
Right.
Send me some of the tomatoes.
Well, when my plants grow up and become big tomato plants, I can probably do that. Right now they're babies.
Use a lot of miracle grow.
Oh, yeah. Exactly.
Go ahead with your thing.
I'm going through the process, you know, the motion anyway. Lots of motion.
Learn by doing. Oh no, that pretty much, I think that covers it. I was just looking at the issues of the original signature document, the dynamics around that. I think you covered that. You just re-clarified for me again the physical possession, because basically, technically, then, if I did do the UCC1 as a notice of claim and the UCC2 as transfer as withdrawal deposit, then they are now in equitable possession by definition, right?
On the second three,
I just ran into a technical problem. Record not found. It says this appears to be a valid amendment file number. Please enter the number of a valid initial financing statement. So they're only going to let me work off the UCC1.
Right. Okay.
So then I go in and I just change my name, and that'll still keep this this UCC3 in force, even though I go in and change the creditors or debtors trustee's name, because I'm going to have to put my name in the trustee box, or however you want to say it.
Floyd, actually curious, since you're working on those things, you remember your UCC1?
Pardon me?
Your UCC1, the notice of claim?
What about it?
I was just curious again, what did you put in for type of organization?
Let me see. Type of organization. Let's see. Well, actually, what I did is I just put in in block 8 grantee grantor nomenclature change, and that's all. I didn't put in any organization.
Oh, okay. Well, and did you fill out the? I just pulled up a copy myself now. Did you fill out the debtor's exact full legal name area first?
Well, I put in, the debtors. I put in the CFO of Sprint as the debtor, because he's going to be the trustee. To see that he's the grantee, and I'm the grantor. So I filled out block 1 and block 3, and I put let's see, a non-UCC filing in block 5.
Okay. Yeah.
So now they're asking me. So I have to put in my UCC1 file number in here. So let's see how that works.
So how did you list the company then? You put in the company name as the organization name, the address, city, state.
I just put in the CFO.
You put in CFO, okay.
Yeah, I just put in the man.
Well, the CFO is actually an entity itself.
Yeah, well, see, I was going to put in Sprint as number 1 trustee, and then the CFO is number 2 trustee. But and I could have done that. I guess it would have worked out okay, but I didn't want to take any chances the first time, So I just went ahead and put in the man and let it go at that. But I'm thinking that maybe what you could do, you could put in more than 1 trustee. You could put in more than 2 trustees, maybe.
Well, I wouldn't complicate it. If you've got somebody that you can correspond and just sending it registered mail to him, assuming it's to him, you know, other people, they'll have to look at it because it's registered mail. Somebody will be opening, whether they open it on his behalf or whatever. It'll get looked after.
Okay, now what this is telling me here is it says, let's see, 2010 blah blah is a valid initial financing statement. File date 5/14. First debtor listed is Robert Brust, and then it says fill in form very carefully. Blah blah. Amendment details. Okay. Now, I wonder how I can work this because it only gives me termination, continuation, assignment, and amendment, party information and collateral change. Amendment on party information and amendment on collateral change. And I can do a partial assignment, but that's not going to help me.
So you're into your UCC3 now.
Yeah, I'm doing a UCC3 on my UCC1, and I want to put my name in place of Robert Brust, but I'm not sure it's going to let me do that. What do you think about that, Christian?
You can't switch the names?
No, it's not going to. It doesn't give me any place where I can do that. It says the only thing I can do is terminate it. So I'd have to actually terminate Robert Brust.
Okay, do this then. If we're going to do the nomenclature change from, say, trustee to grantor, or grantee to grantor, then switch your nomenclatures from that to grantor/grantee on this one. So that will reverse the blocks by nomenclature change.
Optional. Let's see. That would be, okay, optional filer reference data would be grantor, grantee then, right?
Right, because the first one was that you filed was grantor, or grantee.
Grantor.
Okay, yeah, so reverse those. Grantee/grantor.
Okay, then if I do that, then it'll show what? It'll show Robert Brust then as, it'll show him as the secured party.
Now, you might want to make a slight change to the verbiage in the collateral block and make sure that you distinguish between who you're transferring from and who you're transferring to. And you could put in there transferring from, you know, grantee to grantor.
Okay, let's see if I can find. Oh boy. Well, I would just click assignment again, wouldn't I? Because this is an assignment.
Yeah, you're doing assignment, yeah.
Okay, so let's see.
I thought Christian was on the UCC1, but it sounds like you're talking about the UCC3 again?
No, I'm working on the UCC3, but instead of amending the UCC3 instead of amending the UCC3 that I've already done, I have to go back to the UCC1 and amend it prior to the UCC3 that I'm trying to amend. Okay, so I'm going to put assignment. And then I'm going to put, let's see, whoops. No, it's got last name. So I keep his. I wonder if that's going to mess things up. If I put, I have
He's trying to assign this. Is he trying to? You're trying to assign this to. Okay. Now we're assigning the title.
I'm trying to assign it back to me, Shane. And right now, what I'm trying to do is make this thing work in my favor instead of, screwing me up. Let's see now. I've got right now what it did is I put assignment, and now it wants a last name and a first name, and I'm thinking if I put his name in there, because I'm gonna have to put my name in there, aren't I, Christian?
In what, the collateral block? Or
He's on UCC3.
It's in the, it would be in the, let's see, assignment full. Okay,
well, let's just
a full assignment.
Just ask a question.
Give names of assignees. Okay, so it's the assignee that I have to put the name in. So that would be the grantee. Let's see. Yeah, that would be the grantee. And I have to switch grantee, grantor, and make the grantee. Let me see.
Just want to ask a quick question here, Christian. If so, to think about it again, just to go back to basics here. UCC3 as assignment, which is causing the assignment is the transfer. Is that right?
Right.
Okay. Then, and in the process of doing this assignment, which is a transfer, we are, let me just go real slow here now. We are transferring the legal title that they had by presumption. Now we're specifically hold on. We're doing the UCC3 transfer as a sorry, I just lost my wording here. As a withdrawal of the general deposit, right?
Right. When I gave them my name on the documents, I also transferred, not knowing, the legal title to the documents to them.
Right, by presumption. Now we're going to state
the documents are theirs. They have possession of the documents and also title to the documents.
Yeah, in a way, that's how they're kind of playing. They're confusing us too by not really clarifying legal title and physical possession So, okay, but now we're clarifying it, saying that's all fine and dandy. You've got the legal document with the original signature, safe in your safe possession, physical possession. And now we are doing this in case there's any rebutting. This is rebutting the presumption in my mind very clearly now. So we're doing this assignment, and we will be using this assignment as a transfer of, in case there's any question, and to show our intent. So this is a record of our intent, right? The legal possession of the title.
It's the withdrawal of the legal title from their. I don't want to say that they're
as a withdrawal of from.
It's withdrawing their ownership of the legal title from them. I'm reversing it, withdrawing it back to me.
And we can state that the proper verbiage in a general statement, because really when we're saying as withdrawal from general deposit is kind of a generic statement, but it's fundamental in its meaning.
Yes.
Okay. And so there you go. So that becomes the powerful record that it is.
Yeah, I deposited with them the documents along with the the legal title. But they're two different things.
So
they can keep the documents, but give me back, I withdraw the ownership from you guys back to me of the legal title.
Yeah, the title. So we are acting as the grantor in this and as the assigner in this.
Right. Because it was my intent that it was supposed to be a special deposit, not a general deposit.
So, in a way, this is our declaration of intent as well. This is part of falls under, because I guess all of it is the UCC1 and the UCC3. The first, we have to start designating as UCC3A and B, but that's all part of this declaration of our intent then, isn't it?
Right.
Okay.
Okay, what it's wanting me to do is it says give names of assignee or assignees. Also provide name or names of assignors in the authorization section. So let's see, the authorization section, what would that be? That would probably be an optional filer reference data. Wait a minute.
So what do you ask employed? Who's the assignee and signer?
Well, what they want, when you click assignment, it says full or partial, and I'm doing a full. Give names of assignee or assignees. Also provide name or names of assignor or assignors in the authorization section. And then it wants individual or organization, so I click individual. Now I have to put in either my name or Robert Brust, and I'm not quite sure if I put in Robert Brust. I mean, I've already assigned. Well, let's see. I'm assigning him as. I'd be assigning him as Grant.
Well, try this, Floyd.
Grant, I'd be making.
What's confusing is you're confusing with the first UCC3 that you filed, and just forget that isn't. Let's look at it like that's never been done yet. And now you got to do a UCC3, transferring it back to you.
And you're always the grantor.
Okay, so now I've got to put my name in here.
Well, hold on. You said assignee.
This is going to make it so that you get it back, transferring it back to you.
I do see a little bit of what he's saying, because I'm looking at the document. But just first off is, Floyd, you or me or whoever's doing it, you're the grantor, and you're the one that's doing this action. So you're also the assigner. But I can kind of see what you're saying. I think, like in the process of doing this, let's see, you'd be looking at it, and you'd be saying you as the grantor and the person doing the action as the assigner are, in essence, you're trying to assign or transfer the title from the, let's say it's the, we'll call it the corporate CEO, to you. So in the sense, you're the assigner because you're the one doing the assigning. And so I think, but I guess it feels like you're kind of maybe confusing, like, because it kind of sounds like, oh, well, if you're bringing it from him to you, it almost sounds like he's assigning it to you, but you're essentially assigning it to yourself because you're the one that's.
I am, but when it's all said and done, it has to show that I am the that
assigner.
Well, yeah, I am the that's not going to change because I've already put that. That's already filled in. But as the secured party or the trustee, now I'm going to have to or I mean as the see, I have to be now. I have to take the place of the debtor because he's oh God. That's what's
I don't think you even want to be thinking about debtor at all. I mean, you're just using that sheet. You're not using, it has nothing to do with debtor or credit.
I know, but I know debtor is trustee.
Okay. If you want to use that.
Well, that's I don't know how else to say it. It's either debtor or trustee. I mean,
Yeah, can't
Sure.
you transfer from the trustee to the grantor?
pardon?
And can't you transfer from the trustee to the grantor?
Could you put those terms right in it? Put like CEO as trustee and your name as grantor, like in brackets beside it? Would you do that, Christian, on the document?
I could put it in collateral block, but I don't think I can put it on the form on the computer.
Yeah, maybe in the collateral. Yeah. Okay.
Well, I can put I can switch grantee grantor in the collateral block, or I mean in the filer reference block, the optional block, and then in the well, I'd have to go back to that'd be let's see.
Well, how does it say that a transfer is taking place from whom to whom?
Transfers taking place from whom to whom? Well, the transfer is taking place from well, let's see. I've transferred it to Robert Brust. So now it's going from Robert Brust back to Floyd Howe. Right?
Right.
So how do I? So I need to show that on my UCC3 after it's all said and done.
Now, on the form, how does it say it's transferring from whom to whom?
Well, this is what we're getting down to.
Well, let's see. The first debtor listed is Robert Brust.
No, how does the form work? It transfers from whom to whom?
What have we got to work with? Let's lay that out. You've got the Part B send acknowledgement to. Then you've got 1A initial financing statement file numbers. Skip that one, I guess. 2 termination, skip that one. 3 continuation, skip that one. So 4 assignment, that's what you want to check off there. Then 5.
What are you looking at, Shane?
UCC3.
All right, you got.
So I'm down to number 5 now. There's amendment, party information. I don't know if that might be something. This amendment affects debtor or secured party of record. Now, we can't really use that unless it's in a colorful sense. I'm not too sure about that. And then there's 3 boxes. I think change name, delete name, or add. We're not using that. So you're down to 6 and 7 there, which is the current record information and the change, new, or added information. And I think is this where we want to focus our attention? Is this what you're getting at, Christian?
Well, what's those 2 blocks?
Sorry?
What are those 2 blocks? What's your titles? What are the 2 blocks?
What's the other boxes for titles?
Yeah, what's the remaining 2 blocks? What's their titles to the blocks?
Well, actually, no. When I'm looking at this now, I would be hard-pressed to see exactly how to lay this thing out. Because he's referring back now to his UCC1.
Yeah, but if we're just looking at the UCC3 form, it's transferring people from somebody to somebody else.
Okay,
What does the form say it is transferring from whom to whom?
Well, it's not specifically a transferring form. Basically, the UCC3 is a financing statement amendment.
We're signing somebody to somebody else.
Because it says in box 7, it says changed or new or added information. So the new information was Robert Bruss the first time. So Robert Bruss became, let me see, Robert Bruss became the, he became
I don't
the,
think it's,
he became
it's
the,
not,
wait, now, let me think here. Okay, he became the assignee, because I've got a signee and a signor. And
how about this? It doesn't. There is nothing here that says who you're taking it from, who you're sending it to. That first 6 says current record information, and 7 says changed, new, or added information. Not really doing any of those things. I wonder if you just go straight to the collateral and just say it straight right there.
Well,
Does that make sense?
Signor in this form.
The assignor is going to be Floyd.
Well, how does the transfer take place? It takes place from the assignor to the signee. Who is
Maybe
the assignee? Who are the parties?
Can he not just say something to the effect of Floyd so-and-so, acting on behalf of Floyd so-and-so, if he wants to, depending on how he wants to treat in relation to the name?
No,
it comes down to the blocks. Which blocks is the assignor and which block is the assignee?
Number 10.
Identify that, and you got the key to the puzzle.
We only got 6 and 7.
What do you mean? We got number 10. That's the block that identifies the assignee and the assignor.
Oh yeah, sorry. Hold on. Yeah, 9 and 10. Well, yeah. You're the secured party. If you want to use that, would put you towards the grantor again. There's a colorful secured party.
Okay, see now.
Who's the assignor? The secured party?
The assignor right now is Floyd Howe.
That doesn't tell me nothing. Who is?
Huh?
What is the secured party as a colorful party?
Who's the assignor on the form? What block? Is it the secured party or is it the debtor?
Would obviously be. Who's the assigner?
It's the secured party is the assignor.
Right.
Are you sure?
Well, that's what it says. Name of secured party is Floyd Howe, and he's in the second position on the form. And it's
the forms say the secured party is the assignor.
Yes.
No, it says, well, yeah. Name of secured party of record authorizing this amendment, in brackets, name of assignor, if this is an assignment.
Okay, so now we know for a fact that whoever is in the secured party, which is going to be your nomenclature change to whoever you're going to change it to, that is the assignor. That party does the assignment. So
yeah, which says right in there.
So secured party is which block?
9.
Number 9.
Number 9.
Yeah.
So it says it right in there. It says name of assignor if this is an assignment.
Okay. Now, give names of assignee. Okay, so the assignee. Okay, the assignee. I would have to put my name as assignee then on this one, wouldn't I? The one I'm doing now. Huh?
I would think so.
Yeah. Okay. Let me see. Let's see what happens.
Where's assignee?
Now, where is it going to be assigned to?
Well, hold on. He just said he wants to put himself as the assignee.
Or he said he's going to be the... No, he's got to be the assignor, and it's going to be assigned to him.
I know, but I think he just confused himself in that last second there and said, I think I'm going to put myself as the assignee. Correct me if I'm wrong there. It's like, you're the guy who's authorizing this amendment, right on number 9 there, right after name of secured party, of record, authorizing this amendment, then in brackets right beside it, name of assignor. This is, if this is an assignment, which it is. This is specifically an assignment. So you are the assignor.
But I'm going to become the assignee because I'm going to switch assignee, assignor to assignor, assignee.
Well, this is a good question. This is where I was thinking it can get kind of complicated because there's the assignor, the person's trying to authorize the record of this assignment of the title from, let's call it the corporate CEO, to yourself. But it's not him that's assigning it to you. It's you are assigning it to you.
Right. Right. Now, will the form allow you to do that?
Sure. Why not? This is kind of getting to like the man and the name thing. This reminds me of Winston's thing that we were dealing with, right? When we were setting up, trying to put a lien, or he signed it once as uppercase name, and I think he signed it again as signature, right? Mm-hmm. Now, I don't know about the logistics of that, but still, in principle, he's operating as the assigner and the creator of the record, so he has to be the assigner, and he's assigning it to himself.
Right.
All right. So now, where are we? Am I putting my name in here, or am I putting Robert Brust's name in here again?
In there, though. Now
to put in there where you're signing it from. It's just the assignor is assigning it to the assignee, and you are both parties.
Or he could be, and he could be a assignor on behalf of the CEO, John, whatever his name was. Could he do that, Christian?
Well, I am the assignor. I'm the assignor. I'm the assignor assigning it to the assignee. So the assignee in this case is Floyd Howe.
Right. You're both parties. You're assignor and assignee.
Right. So that's why I'm going to fill out my name and put it in here.
Mm-hmm.
I can see how that would be confusing you a bit there. But now you can see it, I'm sure, though, eh? You're the guy creating the record, so you always got to be the grantor. You're always going to be the assignor. And then the extra thinking part is just to realize you're doing this on your own behalf.
Yeah, they're just a holder of the documents. There was a mistake that needs to be corrected.
I guess they'll be getting a copy of this document. Does that matter, Christian?
Well,
I always get required
what you're doing there, or else how are you going to have some kind of record?
Right. So they get a copy for their records. It'll be publicly recorded, and you'll be getting your copy. Everybody gets a copy.
Yeah, I get a certified copy. If I don't have a certified copy, then I can't make copies from the certified copies, and I can't give any copies to anybody.
Okay.
If I don't have copies, how am I going to give them?
Now, where is he? So now we know where he's putting himself in Section 9 as the assignor. Where else is he putting himself as the assignee then? In that gets back to number 6 or 7 there, changed new or added information or current record of information.
Yeah, so when he signs it the second time, he's still going to be a signor, although he's been assigned as the signee. He's still the assignor. He's going to sign it again like he did on the first time on the UCC3, signing it to him, to the bank.
Well, on this one though, where's he putting the assignee? Floyd, do you know where you're putting the what number box you're putting yourself as the assignee?
Yeah, I'm going to be in number 7.
7. Okay, changed or added new or added. Okay.
No, wait a minute. I'm going to be. Yeah, I want to be a signee, so I will still be. So I'll be in box number 9 because I'm going to change assignee. So.
Oh, hold on. Got to stop you right there if you don't mind. You can't change that box number 9 to the assignee position. It's clearly labeled as 9, secured party of record authorizing this amendment, and then name of assigner if this is an assignment. So we've got it clear. This is an assignment. You are the assigner. Your name goes there. That's done. You got to treat yourself like 2 different people for maybe to keep this picture clear. Now you're going to sign it to yourself. But so you are the assigning party, and you're assigning it to yourself as well. So you're both parties. So just visualize yourself as 2 people there.
Well,
so you can't go back into the same box. You're done there. You put your name in, you're done there, right?
If they let me do that, that's what I'm working with. I'm working with whether or not they're going to allow me to supersede Robert Brust for the moment to get back to.
I wouldn't even go there right now. Just try and understand it fundamentally in principle and what the application would be if it was so. Because, I mean, all you're doing is asking yourself if you've got the right of the grantor to be doing what you want to do on the trust that you created.
Okay.
So,
here, let me read to you what it says here.
Christian, did you just hear what I said?
Yes, I heard what you said, but now listen to what I'm saying.
Oh, no, well, asking Christian heard it. I don't think you understood it. You're asking if you've got the power of the grantor to
I understand that, Jane. I understand that. I can be the assigner and I can be the assignee. I understand that. I have no problem with it.
What your question turned around is...
I'm saying that, no. I'm working with...
Your question, though, was, will they allow it?
Listen, I am working with a form here, and it's asking me questions, and I'm filling those questions in. Now, when I get done, it's going to look on the form the way you're looking at it. It's either going to be right or it's going to be wrong. And it's going to cost me $11 to find that out. So I want to make sure that it's going to be right before I spend $11.
So my question back to you was hold on a sec. My question back to you before it gets all really twisted inside out, backwards, upside down, complicated, yada, yada, is we're done with the number 9. I just wanted to know where you're going to put it. You said number 7. And then I think you had a question saying you're not sure if they'll accept that. They're always going to argue and throw stuff at you. I don't know what that means, you know. I don't know how hard, you know, how much stone that's written in. That may be a question that's going to be open. But just to be clear, as far as what you're trying to do, I just wanted to understand that, yeah, okay, we got it clear now. You're the assigner. And then as far as we're looking at number 7 right now, and then, I don't know, if you want to restate your question, I guess, because you didn't really answer my first 2.
Well, number 7, it says changed, and number 7 is going to, if I can put, well, I guess if they'll let me put my name in there, that's fine. So everything will be fine. I can keep assignee and assignor the same.
Okay, so I hear it. You still got that question there. And then maybe you can follow it up with like more clarification in the collateral, just to reiterate.
Well, that's what
so
I'm going to do.
Clear.
And I want to get to the collateral so that I can write in there what I want to put in there.
Yeah. They're not making it easy for us.
Huh?
They're not making it easy for us. I can sort of relate to that. But yeah, I think we got that sorted out. And then how would you put something in the collateral? Something like that you, Floyd, as the assigner, and making this assignment as a transfer of the general deposit, make reference to the document, and I hereby make record. Period.
So what I'm going to put in there is the same thing that I've got right now, except I'm going to change at the end of the sentence. I'm going to put in there as withdrawal from general deposit prior to filing number 2010-134-5703-8.
Okay, gotcha, right.
Okay, now, just a minute. Name of secured party of record. Authorizes. Optional file. Reference. So, then I keep assigner the same then, Christian, I guess? Yeah, I guess I would, because I'd be the name of the secured party, and the assigner is the name of the secured party.
But there is no real secured party. This isn't, it's, if you look right beside it.
I have to go by what they have on the form there.
Well, what it says on the form, the key parts for you, as far as what you're doing with the form, is you are making you are the party of record authorizing the amendment. Then if you look very closely beside it in brackets, it says name of assigner, comma, if this is an assignment. So you're not the secured party, you're the assigner.
Well, it's asking me here, authorizing party, and I'm the authorized party. So it says name of secured party of record. That's what it's saying on this form I'm filling out here, Shane.
What does it say right beside it? Can you not see what's in beside it there?
It says name of secured party of record authorizing this amendment. Name of assigner, if this is an assignment.
My question to you, is that an assignment?
Yes, this is an assignment, and that's why I'm putting my name in there as the assigner.
Okay, so you're not the secured party then, because you're not using it for the function of that. But the word is just there on the paper. You can put a line to it if you want. But yes, you're also the party that's authorizing the amendment, no question, as a signer. I'm just hoping that helps it be clearer for you.
Okay, but just for my own understanding, I keep assignee, assigner, nomenclature change identified the same on this one as what I have already. Right? Isn't that right, Christian?
I had to step away for a minute. I wasn't listening. You have to catch me up here.
Okay. I'm putting my name in as assigner, and so and also as assignee, and so I keep assignee / assigner nomenclature change identified the same.
Right. I would say so.
Okay.
And it makes sense. The assigner being the person doing the assigning, and the assignee being the recipient of the assigning. You're assigning the title to yourself. No one else is going to do it, right? No one else is going to do it for you.
Okay.
The only one who can do the assignment is the one who has the right to do it. You can only transfer only what right you have. So if the bank says they've got the right to transfer or do whatever, but then where'd they get that right from?
Their presumption based on your signature.
Yeah. They're not telling you that you got the right to rescind and call it back, and that way they have no right.
This rebuts that presumption of how you put your signature on there. So that's going to fix it. So they can't say that anymore, and if they do, you've got the record now. That record, Christian, in itself is a form of a title?
Yes.
Okay. And that could be used again well, that's yet another trust, isn't it? Technically.
Could be.
Okay. Well, it's been a while since I looked at those UCC documents.
So Shane, did you think about that pure litigation defense?
To be honest, no. I had too many crazy things come up. Focus, and it wasn't. I'll be honest. It's not clear right now, too, in my head. I got more cleared up on what we were just discussing. Actually, is I think what was it? We're just covering with the possession. I was just more cut up with that. Still playing around with that possessory title, and just actually what we got cleared up today, right now. Again, clarifying that separation between physical and what's the other word for it to be used? It's not physical. I mean, like title. It's not really, even though you can have a physical title. I don't want to call it a physical because I want to leave that sort of for the actual cars, houses, and objects.
Like there's two kinds of possession. There's the possession is you got the goods, but then who has the right to the possession? That's in the one who has the title.
Yeah, I don't want to call it legal fictional, but I mean it's there's the legal arena as far as legal understanding, I guess.
Yeah, the legal title gives you right to the possession, although possession is in somebody else's hands.
Yeah, I'm just saying, how do we refer to that realm? You know, so like we've got the physical realm. There's the roads and the cars and the houses. I call that the physical realm. You know, the tangible physical world. And then I just want to, when I make reference to titles and who's got legal title and equitable title and so on, I guess I'd call that the legal realm, right? The fictional, it's kind of a fiction realm in some sense.
It's assumed that the one holding is the owner or has possession is the right to the title. But that's not so because holding and ownership is two different things.
Yeah. Oh no, this is huge. This is so huge, and again, it always seems to fit with the little bits and pieces we had previously. Although, like I said, I had to go through this major readjustment I've yet to lay this on anybody. I can't wait. It's going to be fun. Oh God. But yeah, no. Actually, can you maybe rough out that whole the issue that you were discussing on the litigation? Or do you want to save that for another time?
No, we could talk about that a little bit.
All right.
It says when you get a presentment, it's really they're looking to get your signature, but really what's happening is they're presenting you with an instrument to cash. They're tendering an instrument to you, and you're the bank. And they're throwing that note in front of you in a mortgage foreclosure and saying, is that your signature? What we really want to know is, are you going to cash it? So if I say, okay, I recognize that this is a presentment for cashing, for tendering, but you guys have to endorse it in order for me to cash it.
Oh, yeah. I remember what you're getting at. Well, that too, again, okay. There's an issue where, you got to create a lot of hypotheticals because, it really is unpredictable what's going to happen. But for the most part, I guess if you're going to put any predictions.
Things are going to happen. Either you're going to fall into a dishonor because you refuse to cash the instrument for them, and they're going to go to the secondary contract, the security agreement, and foreclose on you. But they're foreclosing on payment because you fell into dishonor on the presentment because you didn't know how to do banking.
Right, but unless
whether it was a ticket at a traffic stop or whatever it is, it's all the same thing. We're not treating it as commerce, we're doing banking.
Well, wait a minute. Not treating it as commerce, we're doing banking, you said?
Yeah, we're not treating it as doing banking under commerce.
Right. Okay. Well, the first step you're saying then is, and actually, I guess let's use an example of the ticket just for focus. The police officer is putting his signature on that document, isn't he? But that's not to be. I cannot. My first question would be: could I construe that as a form of endorsement? I would say no.
Yeah, it would be like the second time you're in court. They're trying to collect on it. That's when they're doing the presentment to you for payment.
Okay, and at that point, though, a smart individual with insight would be stepping up and saying, look at that document and say, do you have the document present? You probably have to ask for it because that's one thing. They hide all that stuff from you. You turn around and say, has this document been endorsed? That would be it right there, right? That would start the whole...
Push it, cash it, because now you haven't waived your endorsement rights to challenge the endorsement. If you don't say anything, you waive the right to challenge the endorsement.
Yeah. I think that would stop them right there, though, wouldn't it?
Well, yes. If it's not endorsed, then they refuse for me. It's refusal for me to tender payment to them. They're refusing payment, and that's 3-63, and it's discharged.
3-63 is making a reference to the unviability of an unendorsed instrument?
No. Let me get the UCC here. Okay, 3-603 says under B, it says, if tender of payment to pay is made to a person entitled to enforce the instrument and the tender is refused, there's discharge. So aren't they presenting it to me to pay?
Right.
And when they won't allow me to pay, it's discharged. Now, what makes that I won't? Why can't I pay it? Because they won't endorse it. 3-203.
When you say get just a little bit on tendering, is there a relationship between tendering a document and the endorsement?
Well,
or am I
they're
confusing
presenting
those terms?
for tendering, for payment, to pay.
But they can't properly tender it without the endorsement on it.
Right, because under 3-203C, it says, because of lack of endorsement by the transferee has a special enforcement right to the unqualified endorsement of the transferor. But negotiation of the instrument does not occur until the endorsement is made. You got to put an endorsement on it, or else the negotiation stops.
And that's the tendering party presenting.
Yes. And then it's 3-603, your tender of payment for me to pay. If you is refused, it's discharged.
Oh man. That's good to know it's specifically like that. I wonder though if you just basically call them out that, I think they would just be scared off completely because what could they say? They couldn't even talk about it. They wouldn't want to talk about it. You just look at this instrument. You could turn around and give this instrument.
Let's say they do endorsement now. Well, great. Now I get to look at the endorsement and see whether or not it's the same party as the instrument was made out to. And since they don't match, then I want to know, how did you get this? What gives you the right to cash it? And you better that identifies you as being the owner of the note. Again, like we were talking about earlier, holder and owner. You can be holder and you can be a thief without the right for ownership.
So I think, at that point I did ask you, they couldn't sign it as a representative, let's say of the city, for example?
Okay. Now I've got a qualified right to ask for representative capacity as what gives you the right to cash for so-and-so. In other words, again, I would ask you for two forms of ID, which would be really the chain of title establishing ownership. If you can't establish ownership or a chain of transfers from somebody who has the right to enforce to you, then you're a thief and you have a stolen.
But surely the judge would have, I don't know if he's a judge in that actual capacity or magistrate or whatever, but surely he would be, I think if you did ask them, they would turn around and say something like, I've been granted this title on behalf of the city, blah, blah, blah.
Prove it. Where's the chain of title?
Okay. You have the absolute right of requesting proof.
Yes. If I don't, I waive it, and they get to foreclose.
Oh boy. So even if they did sign it. That's a double whammy then. You're really putting them on the spot there, eh? Just with that too, that's just so simple too, to keep it real simple, clean like that. Can I please see the ticket? I get the ticket if they actually produce it. Because I don't have to carry anything in with me. And I look this instrument over. Is this the instrument? Okay, great. I don't see any endorsement here. Here you go. Who's going to endorse this? Should I give this to the prosecutor? Play it up a little bit? And then even if they went as far in the absolute unlikely possibility that they sign it, I could then turn around and say, okay, sorry, whose signature is that? Okay, and I need to just see some proof of authorization.
I endorse it and tender is refused, and it's discharged under 3-603.
Yeah, that's the 95% possibility. But
right, so
the 5%.
They endorse the instrument. Now I got the right to ask them for identification. And the identification, you got to prove that you're owner of the instrument, as well as, I know you're holding it because you're presenting it to me. So, but that doesn't give you, holding does not give you ownership rights. I want to see your identification that gives you ownership rights. I want to see the transfer of titles that gives you ownership rights.
So in the 5% possibility where they even sign it, then it's just, you still come back with proof of capacity, essentially.
Yes.
Right?
Now, when they can't prove the identification, 3-504 comes in. 3-504 comes in, because that's my excused presentment and my excused notice of dishonor. That way, I don't fall into a dishonor by not cashing the instrument, because I made the offer, they endorsed it, but there's something missing, and I don't fall into a dishonor. It's excused because there's a missing endorsement. Under 3-503, under A, under Section 5, the drawer instructed the drawee not to pay or to accept the draft, or the drawee was not obligated to the drawer to pay the draft. Now, if they don't prove the chain of titles, I am not obligated to pay the draft under 3-203C. And now I have an excused dishonor, an excuse from the dishonor, falling into a dishonor, and they cannot foreclose on me because I didn't fall into a dishonor. You got a win-win situation, but you don't know how to do banking.
So you can do that whole process off of those 3 UCCs you got there, the 3603 and the 3203C and the 503. You made reference to 503A Section 5.
A5.
And then you also made reference to 3504 as well, I guess. So they kind of go together.
Right, and that's got nothing to do with trust, nothing to do with litigation. That's just strict banking regulations under UCC.
Wow, I wonder if they know that.
Christian?
Yeah, Jacob.
I just got on, so I kind of missed everything, but I heard the last 10 minutes. And I just had a question about everything from 3.203 to the 503A5. In that this is strictly banking regulations, in a judicial, non-judicial format, how do you perceive the best way to work it in?
Non-judicial?
Yeah.
Well, I take a notary with me. When the notary, when they don't do the endorsement and approve up the dishonor, either under the 3-603 dishonor there because it's refused, it's discharged, or under the 3-504A5 because of lack of endorsement, I'm going to have the notary do a certificate of dishonor on them under the 3-505. And that's going to be my notice of claim under 3-305 of a
Okay,
defense.
notice of claim 3505.
Right. 3-305 and 3-505. 3-505 is the notice from the notary of the dishonor. That they fell into dishonor. I didn't fall into dishonor. They fell into dishonor. Then I'm going to give notice of the claim when I give them the notice, and that's 3-305.
But is this in pre-discovery or discovery in the case, or?
That isn't even in court. That's doing it with a notary on a non-judicial foreclosure.
Oh, okay. So administratively, you'd call it, right?
Yeah, the notary is going to certify their dishonor. Then I can go into court and get an injunction and have them all discharged and thrown out because that was the payment, and they dishonored under 3-603. Or if they did an endorsement and they didn't prove up the chain of titles, then it's still under 3-504. And it's all
So
certified by the jury.
That's amazing. That's a completely scalable. That's so fundamental. You can scale that right up to a foreclosure type of situation. where they're coming at you for any kind of payment, essentially.
Yes, any kind of instrument, even if it's in the mailbox coming at you. It's really coming at you under 3-115, incomplete instrument, looking for a signature, an endorsement. Now, the question is, whose endorsement do you want to put on there? Whoever has to be put on there. Depends on who's doing the tendering or who's doing the cashing.
Will there also be the same thing with a state statute?
Yeah. In Florida
Okay.
here, it'd be 673.603.
Okay.
And 673.203.
Would in Florida, I'm just thinking it's going to be somewhat similar to the answer to the question I'm going to ask as to California in this context of the question. When you have the 3-305 and then you have the comporting state statute, with the state statute, wouldn't there have to be compliance with the Department of Financial Institutions?
No, this is all UCC. All in negotiable instruments, Article 3. That's where a note falls under.
Okay, but I mean the agency that the state has for complaints when they don't when they dishonor that statute is the Department of Financial Institutions. In each state, they have one.
I'm not following. Each state has a financial institutions.
No, each state has a Department of Financial Institutions,
Right.
which works alongside the Office of Administrative Hearing, which oversees the state courts. So, I guess my thing is that I would, if they didn't comply, I would hit them and administratively to exhaust my state and federal
Well, in a non-judicial state, once I got the notary, now I can come in because I got documentation to prove that they fell into a dishonor on a
Right.
presentment. And I could come into a judicial action and put an injunction against them, and have the court of equity come in and throw this all out.
Okay.
Because there's a dishonor already. They've dishonored. I made an offer to tender it, and they refused tender, say. Or they didn't come up and prove the chain of titles. So they didn't prove that they were owner, and the notary certified all this. And now we don't come at the at-law side, we come at the equitable side under a court of equity, and we come at them with a court action.
And all those records would make it a bit of an equitable, that would give them the ability to make an equitable judgment.
Right.
Is that right?
Right.
That's why they always ask you to make records of everything. God.
Well, we just don't know how to do banking.
Well, everybody, should just stick to the basics and do the right thing, keep their nose clean, be honest, and make records of everything.
Yeah.
And I think that's all they want to see. They'll help you out.
But they got it set up so that you waive a lot of stuff if you don't know what to say. Because
That's right.
You didn't know the rights that you had that you gave away because you didn't ask for them to do the endorsement. So you fell into the dishonor, and they ended up foreclosing on the contract. They jumped from the note on the presentment on doing banking. When you fell into dishonor, they went to the security agreement and got you under a contract. They foreclosed on the contract.
So if the judge takes that route and you did have solid evidence and he breached public trust, have you worked on an area where you can get the judge to comply?
That's equity. equity is going to say that which has been done ought to be left alone. Now, they fell into a dishonor. That's your stare decisis collateral estoppel. That's your dishonor from the notary. Says where the tree lies when it fell, that's where it is. Nothing's unchanged. Where it lies, because it's already been done. That's equity. You already fell into a dishonor. The tree lies right there. The facts are the facts. There's a certificate of dishonor from the notary. Can't change it. You went through the red light. Stop sign. Doesn't change the fact that you went through it. You turn around and go back and go through it again. It's already been done. That bell's already been rung.
But as we're going through the 303 to the 503, 504 UCC area, we're working on statutes and codes with them, and then we want to switch to equity. So is that equity on the public side?
No. That's equity on the private side.
So how do I switch? How do I switch over?
It's not a switching. It's
you got the dishonor under UCC under Article 3. That's statutory. You notary certified the dishonor. With that dishonor, you're going to go into an equitable court, and you're going to get the dishonor, and equity is going to say, hey, it's been already adjudicated by the notary. It's been stopped. It's been discharged according to UCC 3-603.
I see. Okay. That sheds the light